the oldest award given by the National Association of Women Lawyers, the Arabella Babb Mansfield Award is named after the first woman admitted to a state bar in the United States. This award recognizes lifetime professional achievement, positive influence, and valuable contributions to women in law and in society. This year's award goes to professors Leah Litman, Melissa Murray, and Kate Shaw for their significant contributions to public understanding of the U.S. Supreme Court and legal culture as constitutional law scholars, and for their influential work on the Strict Scrutiny podcast.
Mansfield is admitted to the Iowa bar in 1869, so that's an important moment. And also, there's an important moment that sort of points in the other direction 4 years later when the Supreme Court rules in Bradwell versus Illinois that the state of Illinois, right, neighboring state, can continue to exclude women from the practice of law and from the bar. So that, I think, sort of split screen is, I think, a really important and revealing one in a couple of ways. One, progress and equality are not linear. And I also think they drive home that in moments in which the Supreme Court sometimes fails us in essentially implementing the full guarantees of equality and liberty in the Constitution, states can sometimes fill the breach. So when the Supreme Court said Illinois could exclude women, Iowa could actually include women.
Two things that I, at least personally, kind of draw from Arabella Babb Mansfield's career. One is the I'm going to do it anyway energy that I think we all need to replicate. And the second is fighting to break into spaces and positions of power and authority that women have too long been excluded from.
For many of the women who have gone before us, they were often the first and the onlys in their respective fields and spaces, and that can be really lonely. And I imagine it was incredibly lonely for Arabella Mansfield. And I think it's kind of lovely that her name today is one that is used to make sure that women are not the one or the onlys in the fields where they're represented.
I'm Leah Litman, a professor of law at the University of Michigan Law School, and starting the podcast was, I think, a combination of working out various feelings that I have about the Supreme Court and also the Supreme Court commentariat, and wanting to elevate the voices of people that aren't always heard about the Supreme Court, and in a tone and in a register in which the Supreme Court isn't often talked about.
I'm Melissa Murray, and that's one of the things that we've been very particular about on the podcast. We've really wanted to elevate the individuals that we feature to make sure that there's a wider range of expertise that's both seen and recognized as expert about the court.
And I'm Kate Shaw. I just said yes when Leah approached me and Melissa about launching this podcast. 6 years ago, almost exactly, in June of 2019. And I think this was a kind of moment of transition for the Supreme Court. You had Gorsuch, relatively newly installed, and Kavanaugh as well. And it was pretty clear to us that the court and the law were going to be undergoing some major changes in the coming years. And we really wanted to add a different kind of voice and analysis to how people understood those changes.
This podcast had to be a podcast that lay people could listen to. You didn't need a law degree to listen to the podcast. And we also wanted it to be fun, maybe a little irreverent, to sort of demystify the court. These are normal people. They get up every day, they double park to pick up their barbecue, like they're normal people. And it shouldn't be the case that what they say and what they do are beyond analysis. They're an important part of our society. They make the rules of the road that we all have to live by, whether we want to or not. And we should be talking about them the same way we talk about anyone else in our system. It's been a really eventful term for the court, and it's been a really eventful couple of terms. In each of the last 3 years in which the court has had a 6-3 conservative supermajority, it's overruled a major case in every one of those terms. So 2022, the court infamously overruled Roe versus Wade. In 2023, it overruled the line of cases that culminated in Grutter versus Bollinger. And then just last term, it overruled Chevron. This term, we have this absolutely cataclysmic ruling on birthright citizenship and nationwide injunctions that I think is going to set the stage for really reordering the relationship between the executive, the courts, and the people. And I'm not even getting into some of the other cases like Skermeti and Medina that have real consequences for the health and welfare of women throughout the country?
I would actually say two decisions that weren't on the regular docket, but were orders and decisions from the shadow docket, and that's DHS versus DVD, the case about third country removals, and then Trump versus JGG, which was one of the initial Alien Enemies Act cases. I think those two cases are so significant because they are instances where the Supreme Court blocked or paused lower court orders, removing the government's continuing obligation to comply with the lower court orders that, in my view, the government had clearly violated. And so, in that sense, they are disempowering lower courts at the same time they are empowering an administration that is attacking lower courts and the legitimacy of having lower courts enforce the law against the administration.
And maybe I'll just take one more beat on a case Melissa mentioned, United States versus Scrutiny. So the kind of bottom line holding of the case, the court upholds Tennessee's ban on gender-affirming care for minors, but there is a great deal of reasoning in the opinion that also calls into doubt long settled precedent regarding the equal protection guarantees of the Constitution in the context of sex equality. So the court revives the opinion in Geduldig, a case that was sort of part of what is often considered the anti-canon. The court held in that case that as a matter of constitutional law, pregnancy discrimination is not sex discrimination. And the case sort of lay dormant as Congress repudiated its logic as a statutory matter in the amendments to the Civil Rights Act and the Pregnancy Discrimination Act amendments. And generally speaking, the logic of Geduldig has been viewed as wildly wrong, and the Supreme Court clearly revived it in Scrutiny, and seems to be laying the groundwork for really reimagining many of our long settled views about how sex equality guarantees are provided by the 14th Amendment and how laws that distinguish on the basis of sex are to be scrutinized under the Equal Protection Clause.
So much oxygen has been sucked out of the room with everything the Trump administration is doing that there has just been precious little coverage and focus on the Supreme Court. If I had to identify two decisions or rulings that we haven't yet talked about, I would probably say Medina versus Planned Parenthood, which said, patients and providers cannot enforce a federal law when states violate it by booting Planned Parenthood from the Medicaid program. That decision is not just about Planned Parenthood. It effectively greenlights states' ability to bounce any provider out of the Medicaid program in violation of federal law. I also think Mahmoud versus Taylor, which recognize that parents have a right to opt their children out of certain instruction in public schools. That decision is potentially going to blow a hole through the existing law concerning public education, but also laws that burden religious practices more generally, because we just don't know what the Supreme Court is going to say is the precise set of policies that they feel are so severe a burden that they are just going to review and treat differently than others.
This is, again, dealing with the question of anti-discrimination law, and specifically employment discrimination law, Ames versus Ohio Department of Youth, in which the court said that the evidence that a litigant has to proffer in circumstances where she's alleging workplace discrimination, but her supervisors aren't necessarily of a group that would be likely to discriminate, it is just not necessary. I think that is going to open the door for a lot of other litigants, perhaps men, for example, claiming that certain workplace provisions to increase the representation of women and other underrepresented minorities, they will have a lower bar to clear in making those claims of reverse discrimination going forward. And that wasn't a case that got that much attention in the mainstream media. It went largely overlooked, as did, I think, a quite significant concurrence from Justice Thomas, where not only did he sign on to the majority's reasoning here, he actually said, I would go further and completely reevaluate the McDonnell-Douglas framework for dealing with the burden shifting in employment discrimination cases. So that is an invitation to new litigants to bring claims to undermine or hobble McDonnell-Douglas.
The Supreme Court, in a May order, essentially put on hold two lower court opinions that had found that the Trump administration's executive order banning military service by transgender individuals were likely unconstitutional under the Equal Protection Clause. So in carefully reasoned rulings, lower courts had found that that order likely violates the Constitution. And the Supreme Court, without a word of reasoning, put those lower court rulings on hold and allowed the administration to begin implementing this ban that involves actually discharging active duty military service members, many of whom had quite distinguished records. The shadow docket is always undercovered as a part of the court's work, but it is increasingly, both in volume and actual impact, an important, sometimes a more important aspect of the court's work than its merits docket. And I do think that the press that covers the court is still catching up to that really important change in the court's practices. Equally important is the court's willingness to disrupt long-standing practices of the executive branch, of the lower courts, in ways that don't always necessarily translate into headlines, big case X overruled, but can have enormously destabilizing effects on the practice of law. I mean, one, of course, example is the Trump versus Casa case, finding that lower courts and maybe, courts in general, with the exception, sort of under-explained exception of the Supreme Court, do not have the power to issue nationwide or universal injunctions. That is something that courts have issued regularly in recent years. And so that is an enormous change, I think, in the way lawsuits will be framed, brought, and decided.
The court also declines to overrule cases and invents a bunch of ridiculous distinctions with those cases, and in so doing, makes a mockery of the law. In Mahmoud versus Taylor, the court announced that, when something is an objective, real threat and danger to instilling the religious values in your children, then we don't have to apply our prior case in Smith. These are just kind of nonsensical word games. When the Supreme Court allowed Donald Trump to fire the heads of two multi-member commissions, they added, but not the Fed, because that's a unique, quasi-private, distinct entity with a discrete historical tradition. Those are just words that isn't law, which, again, they are just making an utter mockery of.
It's not simply that the court is ignoring precedent. Sometimes they're ghosting precedent. A really great example of this is Smith, which, as Leah said, in Mahmoud versus Taylor, Smith is directly on point, and the court just kind of poo-poos it and pushes it off. Another example would be Lemon, which the court poo-pooed in a number of cases. And then a few terms ago in Kennedy versus Bremerton School District, the court announced that Lemon had been abandoned. What they didn't tell us is that the people who had abandoned Lemon had been the court itself that refused to cite Lemon or even engage Lemon. That is a move that they do a lot, and it really needs to be called out. We are so grateful for this recognition. We don't take it for granted, nor do we take for granted the many women lawyers who have supported us over the years, who were there with us at the beginning, listening when we were trying to cobble together an audience. We're just so grateful for your listenership, for your attention and your support. And we're so grateful for this recognition. It really means a lot to us.